In a first for India and Indian company law, the Companies Act 2013 relies heavily on rules to convey the full import of the change in law. Most of the draft rules are now in the public domain for you to read and mull over. Or you can just watch this special edition of The Firm, because today we have a multidisciplinary panel here to take you through the many surprises that these rules have thrown up. I'm joined by Narayan Shankar, Vice President and Company Secretary at M&M, Yogesh Sharma, Audit Partner, Grant Thornton, Manan Lahoty, he's Corporate Lawyer and Partner at LUTHRA, and Vivek Gupta, who's the M&A Head and Partner at BMR. Gentlemen, to all four of you, a very warm welcome. The first issue I want to start with are two definitions that cut across the Act and impact all stakeholders. The first one is the definition of relative. The list of people that qualify as relatives under this Act and these rules is far shorter than what the 1956 Act had, and that should have made you happy. Instead, most of you are fairly perturbed by this definition. Why?
Today, if you see the Companies Act 1956, nuclear family was not there. It was more joint family was invoked. Today, with nuclear family, the whole concept of relative today, whether in terms of independent directors or auditors, there are huge responsibilities cast. And today, with the 15 type of relatives which have been...
But it's still fairly close, right? It's your parents, it's your husband or wife.
It goes 2 generations above,
it's your children and your son's
down.
Children. That's it.
So you'll have to see it from the perspective of, is the concerned director able to exercise influence or control any one of those relatives? So ideally, the suggestion would be to get into, instead of getting into a prescriptive mode, you can just define it as dependent parents or dependent children who are dependent on the concerned director or a KMP, or you have a concept of an immediate relative, or you just say people who are financially dependent on the director.
Okay.
It becomes much more easier.
I thought the list was fairly close. It says spouse, father, father's parents, mother, mother's parents, children, sons' children, not daughters' children, and brother, including stepbrother. I don't know. Do all of you agree with what Narayan is saying, that this list is not good enough, that it casts too wide a net?
No, it depends. I mean, it would depend on where the term relative has actually been used.
So how does it impact auditors?
So for example, let's say auditor gets disqualified to be an auditor if his relative has performed certain acts, entered into certain transactions, or bought certain securities worth, let's say, 1 lakh rupee face value.
Of the company that you intend to audit, right?
Absolutely. Just taking a very simple example. Let's say I have a estranged, financially independent elder brother who has his own business. He cannot enter into and should not have an indebtedness of 1 lakh rupee or more with the company
that you
to which I am going to. And not only the company, it's the holding company of that company, a subsidiary company of that company, associated company of that company.
But is that too much to ask for? I mean, honestly, you know, Vivek, I know you're going to object to it. So is that too much to ask for, that if Yogesh is the auditor to a company, Yogesh's immediate relatives, his brother, his sister, his parents or his children, must not have a financial relationship with that company?
So conceptually, that is right. So I think the good part about this new definition is that the daughter-in-law of my sister-in-law is not included. The problem is that this definition has universally been applied to all situations. So I'm all for it if you say that in terms of disclosure of transactions of the company with related parties, you have a very extensive list. Where I start having a problem is if you tell me to ensure that 2 generations above, 2 generations below, or on people who have no direct control, they should not have shares worth more than 1 lakh rupees. So let's say today I have to audit ICICI Bank. If any one of my so-called relatives in this definition of 15 hold shares with face value of more than 1 lakh, I cannot audit ICICI Bank. That cannot be the intent of this section. So in a variety of situations, different definitions are required.
I get it. So what you're saying is that the long list works if it only pertained to additional disclosures. But the moment you start using the list to make restrictions on what can or cannot be done, then it becomes too long a list in that sense.
And I would even argue it's difficult to administer.
Even for capital market transactions, to make disclosures for this whole host of relatives, it's just not practical at all. The number of situations in India where, like he said, you know, the brothers may not speak to brothers. The information will not be available, one. To which I quite like, by comparison, of course, I quite like the definition that SEBI uses for relatives. Much shorter.
How is it different?
So it basically includes the parents, it includes the siblings, it includes the children of the person, also of the spouse. It's still larger than probably what it should be.
It's the same. It's exactly the
It's
same.
slightly
Parents,
more than that.
siblings.
Slightly more than that.
Parents,
It goes
children.
up 2 level and it goes down 2 level.
And children's
Definition has to
children.
be in the context of the provision you are discussing. If you're discussing independence, it has to be based on financial dependence. If it's for related party, then it's a different matter. It has to be based on the context you are trying to get into.
Okay, all right. I get the broad gist of what you all are trying to say. I want to move to the second definition that again, has many people irked, and that is the definition of related party. And Narayan, I think you're saying that again it casts the net too wide.
Related party today currently is not defined under the Act. Related party is defined under the accounting standard, and they broadly fall into 2 buckets. One, where you can exercise control, and the second, where you can exercise significant influence. Today, under the Companies Act, they have defined relatives 2013, the new one.
So the rules have defined related parties.
Related parties, and the net has widened beyond imagination. For example, a director or a KMP of your company is fine, but if you're saying a director or a key managerial personnel of your holding company, of your subsidiary, of your associate, and relatives of those people are all going to be related parties where you can't have a single transaction with them. Not only that, even key managerial people and their relatives of the holdco subsidiary associates. So if you, just for example, if I can give, suppose a company has say 100 subsidiaries and 10 related parties, 10 KMPs and directors all put together, and even if they have 10 out of the 15 relations alive, so you're talking about 10,000 people who have to be tracked across.
But given the abuse we've seen of related party transactions in this country, isn't it fair that they've expanded the net?
Again, if it was for the purpose of disclosure, it's fine.
But
if you're going
restriction,
to it's going to be restrictive.
But it is disclosure. It's not restrictive, right?
It's restrictive because you can't enter into a transaction with either any of the related parties
without board
approval
or
and
special resolution, depending on what kind of company you are.
And the penal provisions are, you can say, very onerous. In case inadvertently, if a director, even if a relative enters into a transaction, A, the independent director will be disqualified as being an independent, and B, if it is a related party transaction, and if the director concerned would not even be aware that a transaction, he has to compensate the company, and approval has to be taken within 3 months. You would not even be aware that a particular transaction has been actually taken place in one corner.
I get the point.
And I have a slightly different problem, really. I think the accounting standard definition of related parties has to be the same as the Companies Act.
It can't be different.
It should not be different because for Companies Act, for the first time, they've introduced a definition of related party. And this is slightly different from the one that I've seen under Accounting Standard 18.
That's what Nayan pointed out.
Right, but the problem it creates for a capital market transaction is we need to give disclosures of all related party transactions. Till now, we used to align the disclosures to what was there in the accounts.
Accounting standards. Now
you
have two
sets.
definitions
That's
to
right,
work
two
with.
sets, and
This
one
seems
is
to plague
verifiable.
us, right? This plagues us with several definitions that are common across several acts, whether it's
That's
things
right.
like control, which is more complex, or it's things like, related party, which is simpler and should have been stuck to it.
Or even
in terms of one.
KMPs for that matter, key managerial personnel or
Just to
promoters.
add on, and rules provide even functional heads to be the related parties. Now, functional head could be anyone. Functional head is a purchase head, your sales head, R&D head, whether the function is relevant to the company or it may not be so relevant. But the functional heads are covered without any definition for functional heads. So it's got to wait and see how functional heads is going to get defined and interpreted.
I get it. All right. The third definition I wanted to bring in, and it's not strictly a definition, but I'll bring it in nonetheless. And Yogesh, this impacts your fraternity, the issue of what constitutes a business relationship. Because it says that you cannot be an auditor to a company if you have a business relationship with that company. And then it goes on to elaborate that that means any transaction entered into for a commercial purpose. Now, what commercial purpose means is a big question mark, and that again precludes you from, let's say, auditing a company like, for instance, Vodafone, if you have a Vodafone service on your phone, is it?
Yeah. So it's going to be a major challenge for, and in case that we yet to
look. My example was extreme. I don't think that that the Ministry for Corporate Affairs is going to look at it that way. But I'm just wondering, is that how you're reading it?
But the theoretical reading of the rule is exactly the same.
As extreme.
So it's transaction of any commercial purpose. So it could be anything. Now I am a Tata Power user and probably disqualified for being appointed as an auditor for Tata Power. So it's going to create a challenge.
I'm sorry, I want to laugh, but
No, maybe an
it just
extreme.
sounds absurd. It is extreme.
Extreme interpretation, but intent is right. So again, it goes back to the basic fundamentals that auditor has to be independent of the company.
Yeah.
Point is, what is that which should be disqualified from a transaction coverage perspective from for making auditor an independent party. Now, a transaction which has been entered at arm's length, which is there in the related party transaction approval as well. And I think those definitions and those concepts have to be applied
so
even
they should have put arm's length into that. And if the moment they put arm's length into that, then you'd be clear of at least not having to disconnect your power supply or change your service provider,
Absolutely.
right?
Absolutely.
Okay, fine. All right.
Materiality thresholds also in the Act,
Yeah,
right?
I get it.
Holding 1 lakh rupees worth of shares of Infosys, coming back
Face
to my
value, power
face
values,
value,
yeah.
coming back to my favorite example, or Mahindra & Mahindra, is not going to give you any influence on those companies, trust me. So there has to be some materiality threshold which is perhaps even defined with reference to the company in question. The compliance costs for these companies also must be seen. So while rulemaking is a good thing, in principle I agree with you. In principle I think we are headed down the right track. Related parties should be disclosed. People who have abused the system should not be allowed to abuse the system. But in doing all of this, you can't take such extreme steps. The pendulum cannot completely swing to the extent it has.
Manan, I'm going to move to the next thing with you, and that is a bunch of changes that impact the capital markets. Let me start with what I thought was a positive change. Private placements, the limit under the 1956 Act was 50 people. That was commonly understood. Now that has gone to 200 non-QIB, non-employee investors. And if you look at what or how many people can be allotted those shares in a transfer, it actually amounts to 16,000 people that you can reach via a private placement in a given year. That's definitely good news, isn't it?
Yeah, I mean, I think the number is not what probably they were calculating, because the number sounds much bigger than they probably had in mind.
200 is a big improvement
200
from
is,
50.
I think, more than...
And each of those 200 can transfer it to 20 people every quarter. So
That's right.
16,000
So
people.
I think 200 is not such a relevant number now, given that they have removed QIBs from this.
Yes.
In the real world, in the real capital markets world, I think what the real problem was that QIB transactions were not able to conduct the way they wanted to conduct the sale. In the sense they had in a number of situations they had more than 50 investors lined up, but they could not sell shares to more than 49 investors.
Right.
That number is no longer relevant now. It could be 50, it could be 20.
Yeah,
So that's a
QIB
positive.
is out, right?
Yeah,
so that's also
a huge positive.
That they've
They don't count
not
QIBs
included
anymore.
QIBs is a plus.
Huge plus.
That even for non-QIB, non-employee investors, they've liberalized the number not from 50 but all the way to 200, indirectly 16,000. Those are positives.
So the indirect number was always any number, right? There was no number of 20 previously about reselling restriction.
I get it. I'm saying, but they've also thought through that bit, that look, if
Sure.
I allot to you and you sell down, you know, let's also put in a safeguard there. Let it not be that you can sell down to several people, because then I can allot you 1 million shares and you can sell 10,000, you know, in values of 10,000 to hundreds of people, you know. So
I think
they've
what
put
is
in
important.
safeguards.
I think what is important is there should be none of these rules about 20 reselling restrictions, for example, for a listed company. So if I do a QIP transaction tomorrow, a QIB is able to buy shares, he should be allowed to sell the shares in the market next morning, which SEBI allows him to do.
Right.
But now he has to make sure that he doesn't sell the shares to more than 20 investors, which is not something a QIB can control.
So all
in
they
the
need to
open
do
market.
is in that the rule that refers to the transfer to 20 in a quarter, not more than 20, they just need to make sure that that excludes QIBs. That's all
That's
they
right.
need to do.
I would say
No?
not only QIBs, but even if a promoter were to purchase shares, for example, under private placement, he should be free to sell those shares when he can to as many people on the market. So any transaction which is on the market should not have a number restriction at all.
I can see that promoter private placement bit being abused, but we won't get into that. That's your broad objection to private placements. Otherwise, you'd say it's a fairly good development, right?
It
And
is.
it also comes with what I call Sahara proofing, right? There are safeguards.
I won't comment on that, but
50,000 bank account, your name has to be on the form. So they've put in adequate safeguards.
those are the good things, but there are problems again. You know, I think one important problem would be, it's fairly common in India to do a QIP transaction with a preferential allotment to the promoter. It helps probably in bankers selling the transaction because the promoter comes at the same price or around the same price that the QIBs do. Now, there is a cooling off period between two private placements under the rules.
Right.
So you can't do a QIP and preferential allotment around the same time.
Right.
That's one. Second is, every time you need to do a private placement, you need to go back to the shareholders. SEBI used to allow you a 1-year window to do QIP transactions under one resolution.
Let me move to
One
the
positive I just wanted to comment, ESOPs today are out of preferential allotment.
non-employees.
So today unlisted public companies today are generally hard pressed because the number of employees are more than 49 and they are not able to issue ESOPs of more than 49 because of the preferential allotment. Today under the Companies Act and rules, they are at par with a rights issue.
Sure.
So both in terms of pricing and the number, that's I think a positive.
Okay. The other 2 points that you wanted to bring up, Manan, is disclosures and prospectuses. They said that you said that they've asked for sources of promoter contribution, and that's going to be impractical. And then when it comes to offers for sale, a couple of things: interim dividend to be transferred to IPO investors. That's again going to be difficult to do. And expenses, can they be borne by non-offerers or not? Let's start first with disclosures and prospectuses.
In the real sense, promoters' contribution is typically not brought in at the IPO time because the promoters would be holding more than 20% shares prior to them commencing the IPO activity. A promoter could have bought these shares many, many decades ago.
Right.
He may not have the records of how he funded the original purchase.
Got it.
Even if he has the records, it may not always be verifiable, and anything that goes in the offer document must be verified.
Okay.
So it will create some problems, challenges for merchant bankers in being able to do diligence on this aspect.
All right. I'm going to move it on to offer for sale. You've said interim dividend to be transferred to IPO investors. How do we identify that?
Yes, the problem really lies in a situation where you have an IPO where there are new shares, which are fresh issue shares and offer for sale shares. So the investor does not know what he is getting.
Right.
You don't know who you're transferring shares to. So who do you give dividend to? And you can't give dividend to everybody because the company shares are also issued at this point of time.
Okay, Narayan, I'm going to come to you. Your key issue was to do with managerial remuneration, that is the withdrawing of relaxations that were permitted on managerial remuneration by companies that were making either inadequate or no profit, right?
Yeah.
But if you're not making profit, shouldn't the company law tell you it's not a good idea to pay your...
No, today it's more in terms
KMP?
of a level playing field. Today, if you say a standalone company, which is not a subsidiary of a listed company, can go ahead and pay remuneration without any limits, although they have inadequate profits. The MCA had issued 2 circulars in somewhere in 2011, if I'm not mistaken, where they said that A, if you're a professional and you do not hold more than 0.5% of the capital of the company, and even if you have inadequate profits, you can go ahead based on certain conditions and disclosures, you can go ahead and pay the...
Now that has been taken away.
That has been taken away. And the second, if you are a subsidiary of a listed company, there again there was exemptions given, because typically if you say in a big organization it's a talent pool, the talent would be shifted from one place to another depending on where he or she would really be required to go. Today, the MCA circular allows the holdco to take a hit on its they've got a limit of managerial remuneration. If they've got a limit, they can take the hit on its accounts.
Right.
And the subsidiary cash flow will go from the subsidiary. Both these relaxations which was given by MCA
have been withdrawn.
and corporates have acted upon it.
Okay.
So I'm sure that with MCA would definitely consider bringing it back and the rules.
You're hopeful.
To the rules. Yeah.
You're hopeful.
Hopeful.
Okay. The more important issue, and I know that you sounded very agitated when you were talking to me on the phone about this, was the transfer of shares issue, which is that if 7 years of dividend have not been encashed by an investor or shareholder, then the company is obliged to transfer those shares or is required to transfer those shares to the IEPF, which is the Investor Education and Protection Fund. What is your objection to this?
One, it will be against the fundamental principle of right to own property. You can imagine if you're staying in a place or even a bank account which is not operative for 7 years, the only thing which you have to do perhaps to get a KYC done again. But you can't say that if I have a crore of balance in my savings bank, after 7 years I have to claim it from the central government. Or if I'm living in a house, after 7 years I find somebody else staying in my house and I have to claim it back from the central government.
How prevalent a problem is this, where you have, dividend lying untouched or unclaimed for that long a period?
Today, what they've addressed it partially by saying that even if one of the years, if you have, in one of the 7 years, if you have encashed dividend, then you need not transfer it to the
so
IPF.
I'm just thinking, if 7 years somebody has not encashed their dividend, will it be such a big issue if you transfer? I get the principal issue you're talking about, but really if that investor has not come forward to claim his money in 7 years, then it seems unlikely that he's going to come forward to claim it thereafter, or that's a false
You just say,
understanding.
suppose I've got shares of Reliance, and as part of a scheme of arrangement which they did, I get one share in many of those 4 or 5 companies which they have. I may really not even be bothered to encash a 1 rupee or a 2 rupee dividend which they would be giving. But one fine day, I will find my shares, underlying shares, suddenly out of my cupboard or out of my demat account. And even procedurally, if you see the rules, the way they have framed, today they say that the company secretary or any other person can issue duplicate certificate. The shares certificate would actually be in your cupboard. Without your concurrence, I will be issuing a duplicate certificate and transferring it to the government.
That seems illegal on
Similarly, if you have a demat account, how can I just sign on your behalf a DP slip and transfer it?
Okay. Vivek, in M&A, what would you identify as the top changes that these rules have thrown up when it comes to restructuring and amalgamations and all of that?
So I think the first one, and I hope, I call it a drafting error, and I hope it is one, is that the rules, a clear reading of the rules seem to suggest that only a demerger that is compliant with Section 219AA of the Income Tax Act is a demerger that can be conducted under Section 230.
230 is the new 391.
230 is the new 391, yeah. So 230 corresponding to 391 of the New Companies Act. Now, that's very interesting, and I think that's unintended. It cannot be the intention of company law to say that if something does not comply with 219AA and therefore it does not get income tax neutrality, that's a transaction that you can't itself do. So that's point one, which is that they should allow all sorts of demergers to happen, so long as it's fair and they've laid out a full principle
and
of what is fair,
and
it gets approved by
creditors
shareholders, creditors, court, tribunal, etc., etc.
And tax
whatever
consequence on the parties
on the
that
Income
are,
Tax Act. So if it complies with 219AA, it gets a certain tax treatment. If it doesn't comply with 219AA, it does not get those tax benefits.
Got it.
So that's the way I would sort of, and that's why I call it a drafting error, because I don't believe that this can be truly the intent of the department while prescribing the rule.
Could this be, and it may be a drafting error as you pointed out, I'm just trying to understand the rationale to it. We've seen several actions taken under 391 to 394 now come under the tax scanner in the recent last 2 to 3, 4 years, right? So several demerger schemes, etc. The tax department's questioning whether this is avoidance, evasion, etc., etc. Sure. Could it be a reaction to that in some way? Could it be that, look, we'll allow, if the scheme goes through as required under the company law, and then thereafter the tax guy has an issue and, you know, it requires some reversal of the scheme, etc., why not do away with that and say, look, this scheme, just like it needs to meet regulatory requirements, shareholder approvals, creditor approvals, also needs to meet the approval of the tax department. What's the harm in that?
So 2 points to that. So A, the New Companies Act already says, so under the existing Companies Act, when a petition is filed under 391 to 394, it goes only to the Regional Director, Department of Company Affairs for approval. Under the New Companies Act,
it needs to go to a far wider
so
set
it
of
needs to
people,
go
right?
to a wider section of regulators, and therefore it needs to go to the Income Tax Department as well. Once it has gone to the Income Tax Department, then this reason goes away.
Okay.
Point 2 is, principally, if something is fair as an act to be done, because of its tax consequences, it cannot be ruled out by the Companies Act.
Okay, we won't belabor the point. I get what you're saying. Point number 2.
So point 2 is, interestingly, they have also specified the transitional accounting for such demergers.
Again, that's filling a gap of sorts, right? Because currently there is no accounting treatment prescribed when it comes to business combinations.
Yeah, so there are a variety of situations where accounting standards do not exist. That is not the job of Companies Act rules, I think, or companies rules. That's the job of a specialist body that you've set up called NFRA. What they've sought to do is something that I don't have a fundamental disconnect with. So what they've basically sought to do is you will record assets and liabilities at book value, which again goes back to 219AA. So I think this 219AA in the context of demerger has played a very active role in the thinking of the department while framing the rule. So all assets and liabilities to be recorded at book value, and any differences to be broadly adjusted on the capital account. So either in capital reserve or in goodwill. I just find it interesting that this is specified in the rules.
So this should have been left to accounting standards. Why bring it into company law?
Although the saving graces, they very clearly state that till the time an accounting standard comes in.
So it's a transition provision.
So it's a transition provision. So one doesn't therefore have a huge
and the
fundamental
auditor on the
objection
table
to
doesn't
it.
seem to be, sort of objecting to it or upset with it.
I'm actually happy to see that because there is absolutely no guidance on demerger accounting or a spin-off accounting or any type of business combinations except for amalgamations.
Right.
So this really helps in between for some time.
So I completely agree with that. So it helps the auditor. I don't think it's fundamentally anything which is hugely wrong, except that I think that spin-off accounting or demerger accounting is a topic for more detailed exposition and articulation. I don't think 3 sentences to say assets at book value, liabilities at book value, difference on the capital account.
Look, it's a transition provision, so it's 3 sentences. Otherwise, you would have had at least a few pages of rule making on it, right? So be happy for what you got.
The point is there will be at least some consistency as compared to having completely different types. So people do fair valuation and do a fair value based accounting. At least there will be a book value accounting for all entities.
So does that pretty much cover the impact of rules on M&A, or is there another point you want to make?
So the other very interesting point is, I think somewhere the Act, and again potentially a drafting error, somewhere the Act seems to suggest that a capital reduction which goes through 230, effectively 391 to 394, is something that does not then need to comply with the other set of provisions. So if you're doing a consolidated scheme where there's a merger plus a capital reduction, demerger plus a capital reduction, etc., the fact that you have complied with the mother provision, the 230, is good enough. The rules somewhere picking up from the current company's court rules, Rule 65, and reproducing that clause seem to suggest that even if capital reduction is part of a consolidated scheme, it must go through its independent procedure. Now, I don't think the procedures are very different. There are some different timelines at various places and so on and so forth. But I think all of this fundamentally is not required, because if 391 to 394 or 230 gives you adequate protection, then it gives you adequate protection for a capital reduction as well.
Why do you need to break it up?
And I think the Act recognized that fact. The rules somewhere are slightly at variance to that.
Okay.
So therefore these are the 2 drafting errors that I see on the M&A side.
So you mostly raised drafting errors and 1 transition provision.
That's right.
So broadly speaking, you should be happy, because on the M&A front, you don't really have much to contend with when it comes to rulemaking.
Yeah, but...
And you should be happy you're not an auditor, because I'm going to move to the auditor now.
Right. If I were an auditor, I would have moved away from that profession.
And I've just stopped smiling.
Audit rotation. What's interesting in the rules is that we were expecting that they would prescribe a class of companies. They've kept it a narrower class of companies. Yeah. They've kept it fairly wide. So with the exception of small companies and one-man companies, audit rotation now applies to the entire universe of companies in this country, which is a huge change, not just for public listed companies, but for private companies as well. So that's one big thing. And secondly, there seems to be some confusion on whether it's retroactive or not, because we were given to understand that the 2 5-year terms in rotation with the 3-year cooling off period, 3 years, right?
Yeah.
Would apply 3 years within the Act coming into force. Now they're saying in the rules that we're also going to count the audit tenure up to the Act coming into force. Yeah. What does all of this mean?
Sure. I think we're trying to cover a lot.
In 30 seconds.
Absolutely. So first of all, in terms of coverage, I think there are three aspects. One is coverage. Second is in terms of what you stated, retroactive versus prospective. And third is whole gamut around appointment, whether it's 1 term versus a 5-year term. So tenure protection. Okay. So auditor rotation and tenure protection always works together in theory.
Right.
If you're going to rotate auditors every 5 years, you're going to give them a protection for 5 years as well. But I think
you can't take away the shareholders' right to be able to vote them out. So you need to provide for the fact that in every AGM, the shareholders get a right to ratify that appointment, if I can use the word.
Absolutely. At the same time,
you can't take away the right. You can't say, I'm giving you 5 years of guaranteed employment. Nobody gets that in any country, anywhere in the world.
So again, it goes back to the principle, both have to work together. Why would an auditor invest energy, time, skills, money, and developing skills to audit?
Because that's what you get paid to do.
But look at the type and the class of companies you're going to handle. So if I'm going to handle power-related companies, it takes time and efforts to invest.
Look, Yogesh, if you do a good job, there's no reason why any shareholder will vote you out. No company likes to change its auditor, having appointed it for 5 years in the middle of that term, because that reflects poorly on the company as well. It's going to raise eyebrows in the investing community. Nobody's going to do this frivolously. It's only going to happen if there are serious disagreements with the auditor, which sometimes can work against the auditor if the promoter and his team are, sort of opposed to the way you look at some issues.
So nobody is prohibiting companies not to remove auditors before 5 years.
I thought you'd be more upset about the class of companies that
Absolutely, it's both ways. So what I was trying to explain, the principle of rotation and tenure protection working together.
Okay.
Act does not prohibit the company for not being able to remove the auditor before the term. So there is a provision for removal of auditor.
How can you prohibit a company from removing an auditor? What if there's something seriously wrong with the auditor? What if he's not doing his job correctly? I think Narayan agrees with me on all of these issues, right?
The logic of the yearly ratification is in case a disqualification creeps into an auditor in the interim. That's why each year he certifies that he is qualified, none of the disqualification is
and each year shareholders
are allowed to vote.
What are you worried about? In this country, companies have had auditors for 30 and 40 years, and shareholders have never stood up in an AGM and said, oh my gosh, this is 3 decades, let's vote this auditor out this year. It's never happened. It's hardly ever happened.
So let me try and explain to you. I think we are discussing two very, very different issues.
Okay.
One is regarding tenure, whether it's 1 year versus 5 year and a tenure protection. Section 140 clearly provides that auditors can be removed before their term gets over, provided there is a central government approval.
Right.
So if there are reasons, then you have a way to go for it. At the same time, now the auditors will be appointed for 5 years, subject to annual ratification by the members in every AGM. What does that mean? So auditors can also be removed at the end of 1 year. Then we are going back to the past era where we had 1 year terms. So both are in conflict.
Okay.
Let's assume, if not ratified, what does it mean? Does it mean removal? No, the answer is not there. The Act does not state that. It simply says it needs to be ratified, that's all. So that's one part of the issue. Second, with respect to the coverage, covering every possible company, I think...
that's worrisome,
so
because so many companies are not equipped to do this. We don't have the depth in audit firms in this country to be able to do this either.
Or just think of the numbers, 8,000 listed, and 13 lakh registered companies. So we are dealing with a range between 8,000 to 13 lakh companies who may be in between, subject to rotation within a period of 3 years, considering the third aspect of rotation, that it's going to be retroactive, because the rules provide that the past term spent by the auditor with the company is going to be counted for computing either the 5 year or the 10 year tenure.
So suppose you've been my auditor for 10 years, that means that if the Act comes into force today, then your term is already over. So within 3 years, I have to rotate out of you.
Absolutely.
Is that, I've understood that correctly?
Yes.
So I don't have another 10 years. I'm actually delighted with that, because I thought that they were going to allow you to do another 10 years. So 2 more terms of 5 each with the same auditor you've had for 30, 40 years, and then be forced to rotate out, which is perpetuating, a problem in that sense. So,
but the issue
Yogesh, I'm sorry, I disagree with you on this, but I'm happy.
Which is coming up is it appropriate for rules to provide for this?
It should have been in the Act.
Because, absolutely. So independent directors, whether the term is prospective, is provided in the Act specifically. Now, rules, are they going beyond the law, is a point of discussion.
Yeah, fair enough. So I get the pain that you're suffering on both ends of this, though I may not fully agree with you principally. The third thing that you're going to be forced to do now is report fraud. Report material fraud and report it within 30 days to the central government if it is material in that sense. That puts on your shoulders a fairly big burden, and accompanying that is a fairly big liability, right?
Absolutely. And I think there are many variables to fraud reporting directly to central government. I think if you look at the definition and what the exact requirements are, auditors are supposed to report not only committed frauds, but frauds being committed. Now, it's not clear what you mean by frauds being committed. Frauds being committed could be at any stage of the fraud. It could be planning of the fraud. It could actually be the execution.
If you catch someone planning a fraud, you must report them to the central government within 30 days.
So the point is, now, first of all, the principle is good. And it's an inspired principle from United States. The Section 10A of Securities Exchange Act actually provides for exactly very similar type of requirements.
Okay.
But the difference is, and I really believe why those rules are sort of very important for us to understand, because there the reporting is to the audit committee. And in case the audit committee or the board fails to take action within particular number of days, then you go and report to central government.
Okay.
Just to take, and again, in terms of what frauds have to be reported, material frauds have to be reported, which includes frauds which are occurring frequently or frauds which are exceeding a particular number.
5% of net profit or 2% of turnover.
Absolutely.
Yeah.
Now,
frequently is also interesting. Like what? The same fraud 3 times a year, the same fraud
So I'll
once
give you
in
an
a quarter.
example. For example, let's say I've seen many BPO companies have frauds regularly reported with respect to misuse of ultimate client's data, or a credit card misuse, or let's say...
That's not an audit fraud, right? Would you call it a fraud that an auditor would have to report?
But during the course of the audit, you will get to see all of that. You will get to see a reporting being made by the company to the audit committee of the list of the frauds or whatever actions which company has taken.
So you need to then start typing out a letter to the central government.
Absolutely.
Yeah.
I need a permanent typist computer.
And please use that overnight courier because it has to reach within 30 days, which is the other big limitation that you have to face in this.
Perhaps one suggestion which could come out for the rule making is that the 30 period I find is very short. Because by the time you come to ascertain whether it is 5% or 2%.
So you don't have a problem that he has to second guess the fraud, that he has to check on frauds in the making. The bigger issue is 30 days.
At least the materiality concept has come today, so that it's not all frauds which an auditor has to. But at least if the period is enlarged, because sometimes it takes much more time to even ascertain what the quantum of fraud is. So 30-day period I think is quite short.
The only point I wanted to add, which was not on any of your lists, and we discussed this briefly at the top, was that related party transaction disclosures now cut across all companies. All companies with a paid-up share capital of 1 crore or more need a special resolution to approve RPTs. And as you know, in this new Companies Act, interested parties cannot vote in that RPT. I don't know what that's going to mean for several private companies if the interested shareholder can't vote. It is going to throw up some interesting situations, but as far as public listed companies go, I'm fairly happy because this brings in a new governance check, which has been missing in our country. I need quick 10-second wind-up responses from all of you because I think we're entirely out of time, but I'm going to start first with you, Narayan. We'll end with you and your soapbox.
With regard to the related party, the last point.
Across the rules.
Across the rules, I find definitely rule-making power, they've been given enormous, because more than 400 out of 470, more than 300 sections are going to come through.
Let me put the question to you this way. Are you going to have to double the size of your department given the kind of compliance burden this puts on you?
Today, of course, I'll have to go through the Companies Act 1956, 2013 and the rules. It is making the job more and more complicated, and cost of compliance is definitely going to rise. But one suggestion could be, and perhaps it's partly covered under the rules, is there should be some finality from the rules so that compliance-wise, we don't have to keep on changing.
Fair enough.
If it keeps on changing every 3 months or 6 months, or knee-jerk reactions to some issues, then again the finality will be lost.
Yogesh, are you seriously reconsidering your career?
No.
No. So then it's not so bad, right? After all the griping.
Final rules are not out, and my feedback is still to go.
So you think that the government has started with an extreme negotiating position so that by the time we get to the final rules, everybody's sort of found some middle paths to it?
Absolutely.
Okay, that's a hopeful man.
For
Manan?
the private placements, I think I was very excited to see the act, not so happy to see the rules.
Okay.
I think it will kind of bring us back into a regime which doesn't really work in a listed capital market situation. However, on disclosures, I think SEBI is the right authority to discuss and set out the rules. This is a halfway house, really. I don't know why there are requirements to disclose the sources of promoters' contribution, for example.
Okay.
So I think SEBI is probably better equipped to deal with
for
disclosures.
several aspects of
capital markets,
issues that deal
right.
with capital markets. Last word to you, 10 seconds.
So as you said on the top of the show, it's a unique law. Half of the law has to be made through the rules. So the department should realize that they have an enormous responsibility. They have the responsibility that most nations give to a parliament. And therefore they should exercise that responsibility with due caution and with a full process which ensures that we are not reacting too much to short-term swings. So, I think that would be my core message.
All right, with those inspiring words, gentlemen, to all four of you, thank you for joining us, and thank you very much for watching. We'll be back next week.